Thank you, Madam Chairwoman, and let me thank all of the witnesses for being here. I think it is very important for everyone to listen to each other, to your stories, to your legal perspectives. These are issues that this country and my state of Indiana has been grappling with for a very long time. I do believe and have tremendous faith in physicians, and we don't want patients to be powerless, but in my view, information is power, and having more information is power. And having, in Indiana, I think we have some common sense laws that provide those reasonable protections, both to mothers and to the unborn, all while making sure that mothers and doctors are well informed on their options and on the choices before them. In Indiana, doctors do have to provide mothers with basic information about alternatives to abortions, including adoption, providing assistance about being a mother before performing an abortion procedure. We don't ban abortions or tell mothers they can't make their own choice, but we do require physicians to have the responsibility to make sure that people do know they have a choice other than abortion. This bill, H.R. 2975, I believe, would restrict the ability of states to provide that sort of guidance to healthcare providers about these challenging discussions with patients. I'm also concerned that it would restrict the amount of information, which I do believe, again, is power for any patient, rules around, and Indiana's rules around late-term abortions. I'd like, while Ms. Northrup was asked by my colleague across the aisle, Ms. Matsui, clarifying what she thought this bill would do and would not do, I'd ask the other legal expert here at the table, Ms. Collette, would you please tell us what you believe H.R. 2975 would do and would not do?
I'm sorry. Thank you, Congresswoman. Based on the evidentiary standard, it establishes a clear and convincing standard for the state's responsibility to show that, in fact, the limitation or requirement significantly advances the safety of abortion. Given the lack of clear data on many of these things, that standard cannot be met. The Supreme Court has recognized clear and convincing evidence is the highest standard of evidence that we impose for civil matters. In addition to that, the definition of significantly advances is not defined in the bill itself, but there is a direction to the courts to provide the broadest possible interpretation of the legislation. And so it would override the Hyde Amendment, and it would override conscience protections that might find refuge in RFRA or state RFRAs. It is a bill that would essentially eliminate almost every state protection that are afforded women against the malpractice or misconduct of others. For example, I cite in my written testimony a couple of cases where the abortion industry has gone to court to avoid informing public officials where a young girl has been the subject of statutory rape, become pregnant, and had an abortion in that instance. I represented the Kansas district attorneys in a case where that was alleged on the part. They argued that the girl had a privacy right not to have the public officials, the law enforcement officials, know that she was raped. Those sorts of laws probably would fall as well.
Can you talk about Indiana law, for instance, requires parental consent for girls under the age of 18. Can you explain what some of the reasons are why states do put parental notification laws in place and why they've been found constitutional, and would this bill have any impact on that, in your opinion?
Those sorts of laws have been found constitutional where properly crafted. Many states have parental notification rather than parental consent. The court has only addressed parental consent in requiring a judicial bypass in cases where the girl's mature and well-informed, or in the alternative, it's not in her best interest to inform the parents. The reason the court has upheld these laws is because, number one, it's the common standard for almost every medical procedure that parents are involved in their minor children's decisions. So that's an important factor. But number two, they also recognize the benefit of the parent guiding the child in what the court calls the selection of an ethical and competent provider. Dr. Gosnell's been referenced earlier. There are cases in Louisiana that are part of the record in the case before the Supreme Court right now where providers have been operating without a license, where their license has already been taken from them. And so a parent would want to know that, and a parent would be able to help the girl with that. They've also found that the parents have responsibilities to those minors as far as support and for post-medical care. That's one of the biggest concerns.
Thank you. My time is up. I yield back.